Good afternoon. Welcome to the March 24th, 2022 California Board of Accountancy's meeting. My name is Michael Savoy, and I am the president of the California Board of Accountancy. At this time, I will turn the meeting over to Ms. Reed to take roll call and to establish a quorum. When Ms. Reed calls your name, unmute your microphone and state your name. Please remember to mute your microphone once you have stated your name. Ms. Reed? Michael Savoy, present.
Mark Silverman.
Present.
Katrina Salazar.
Present.
Nancy Corrigan.
Nancy Corrigan, present.
Carrie Ann Farrell-Hines.
Present.
Dan Jacobson.
Dan Jacobson.
Dee Dee Owens.
Present.
And Yin Tu.
Present.
We have a quorum.
I would like to thank the CBA staff and the solid team for their assistance in facilitating this virtual meeting. The CBA's mission is to protect consumers by ensuring only qualified licensees practice public accountancy in accordance with established professional standards. This mission is derived from the statutory requirement that protection of the public shall be the highest priority for the CBA in exercising its licensing, regulatory, and disciplinary action functions. Whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. Before we convene, please be advised that this meeting is being conducted consistent with the provisions of Governor Gavin Newsom's executive order extending Government Code Section 11133N122, dated January 5th, 2022, which allows the CBA to continue to conduct meetings via teleconference through March 31st, 2022. At this time, the board will convene into the petition hearings, followed by closed session. After closed session concludes, the CBA will recess for the day and will reconvene at 9 a.m. tomorrow morning for all public session items. Now moving on to agenda items 1A and 1B, with the petitions for Timothy Allen Coons and Leslie Klein. Before we begin, I'd like to take a moment to briefly summarize the process, and then we'll turn it over to Your Honor for the hearing. Before we start each matter, I will ask Ms. Reed, the CBA's Board Relations Analyst, to conduct a roll call to establish the CBA members present for the matter and to establish a quorum, which we have now done. I will then ask any members if they need to recuse themselves from any of these matters. After the quorum has been established and any recusals occur, the administrative law judge will then take appearances and will swear in the petitioner. The administrative law judge will allow the Deputy Attorney General to provide an overview of the petition before us and seek to enter evidence, the petition package, and any additional materials. The administrative law judge will then provide the petitioner with an opportunity to provide an opening statement and present and enter into evidence any additional documents. After which the administrative law judge will allow for the Deputy Attorney General to examine the petitioner. The petitioner shall then be afforded the opportunity to respond. After the examination and response, I will request that the administrative law judge ask Ms. Reed to perform a roll call of each CB member to allow members to ask any questions they may have of the petitioner. If a member does not have a question, simply state no questions. After Ms. Reed is done polling members for questions, I will ask if any member would like to ask a follow-up question. If so, members are asked to raise their hand and wait for me to call upon them. After the CBA member's examination of the petitioner, the administrative law judge shall provide the Deputy Attorney General and the petitioner the opportunity to provide any closing statements or remarks. After the closing remarks are received, the administrative law judge shall close the record. Once the petition hearings have concluded, the members will meet in closed session to deliberate on the petition hearings. One final reminder is when you're asking a question, responding to a question, or making a comment, it is important to remember that the court reporter will be capturing a record of the petition hearing. Please be cognizant not to speak over another person and be close to the microphone on your computer or your telephone so that you can be heard clearly. Now that we've already conducted a roll call, at this time I'd like to turn the meeting over to Your Honor. And one change is we will conduct the Leslie Klein petition hearing first. Your Honor.
Thank you, Mr. President. Do we have Ms. Klein elevated to a panel member?
Sure, I just elevated Klein to a panelist. We'll do a quick mic check. I will send a request to unmute the microphone. You just have to accept from your end. Ms. Klein. This is the moderator, Leslie Klein. I've sent you. Oh, yeah, I see you're unmuted. We'll do a mic check.
Yes.
Thank you, Mr. Klein.
All right, so we have Leslie Klein elevated. I don't see that name on my list, but
this is the moderator. I apologize to interrupt you, Judge Wong. It's call-in user 6 on the panelist list.
Okay, got it. All right, Mr. Klein, can you hear me okay?
Yes.
All right, so before we go on the record, just to provide kind of a procedural overview to follow up to what the president provided. The only thing I'll add to that is what the board is most interested in hearing about today is any rehabilitation you've undergone since your license was disciplined. So you'll hear the Deputy Attorney General talk about the discipline history to provide context. But really, when you're providing your testimony, you should focus on rehabilitation rather than the prior discipline because the discipline has already been established. Do you have any questions?
No.
All right, so let's go ahead and go on the record. We're on the record before the California Board of Accountancy, Department of Consumer Affairs, State of California, in the matter of the petition for reinstatement of restricted area of practice. Oops, I'm sorry, I have the wrong matter pulled up. Do these out of order. All right, here we go. So it's in the matter of the petition for reinstatement of surrendered certificate of Leslie, spelled Leslie, Klein, Klein. It's OAH number 2022-020-047. My name's Quorum Wong. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over this matter sitting with the board. To establish a quorum of the record, to establish a quorum of the board for the record, I request that each member respond audibly after his or her name is called. Mr. President?
Ms. Reed.
Michael
Present.
Sawyer.
Present.
Mark Silverman,
Present.
Katrina Salazar,
Present.
Nancy Corrigan, Carrie Ann Farrell Hines,
Present.
Dan Jacobson, Dee Dee Owens, and Yin Tu. We have a quorum.
All right, thank you. Next, if I could take the appearance of the Deputy Attorney General.
My name is Ted Durkar. Last name is spelled D-R-C-A-R. Deputy Attorney General, appearing on behalf of the people of the state of California by authority of Business and Professions Code Section 5115 and Government Code Section 11522 for this petition hearing.
Good afternoon, thank you. And Mr. Klein, can you still hear me?
Yes.
All right, very good. So as the president discussed before we went on the record, and then I described a little bit, shortly the Deputy Attorney General will provide a summary of your license history and then introduce the petition documents. And then after that, it'll be your opportunity to present any evidence you have in favor of your petition. First, did you have any witnesses you wanted to call on your behalf besides yourself?
No.
And did you have any documents other than what Mr. Jakar is going to introduce?
No.
Okay. So again, I just remind you that the board's focus today is on rehabilitation. Do you have any questions about the procedure at this time?
No.
Okay. If any questions arise during the hearing, please do not hesitate to ask. I'm happy to answer any questions you may have. So next,
Thank you.
You're welcome. Mr. Dakar, if you'd like to introduce your documents or provide your summary, whichever you'd like to do first.
Yes, I'd like to offer the documents first. The board members and petitioner and Your Honor have been provided with a copy of the petition packet. The packet includes 39 pages of documents, and they've been consecutively marked LK-PET 001 through 39. And this packet includes the notice of hearing at page 38. I'd like to mark that packet as Exhibit 1, and I offer it into evidence.
All right, so what I did is I marked the documents as separate exhibits. So Bates numbers 001 and 002 are marked as Exhibit 1. Mr. Klein, any objection to 1 for all purposes?
No.
1 is so admitted. And then Bates 003 through 014 are collectively marked as Exhibit 2. Mr. Klein, any objection to Exhibit 2 for all purposes?
No.
2 is so admitted. And then Bates 015 through 035 are marked collectively as Exhibit 3. Mr. Klein, any objection to 3 for all purposes?
No.
3 is so admitted. 4 consists of Bates 36 and 37. Mr. Klein, any objection to 37 for all purposes?
No.
37 so admitted. And then finally, Bates 38 and 39 are marked as Exhibit 5. Mr. Klein, any objection to 5 for all purposes?
No.
And 5 is so admitted. All right, Mr. Dakar, if you'd like to provide your summary.
Yes. At pages, I believe it is 4 through 7 is the petition form that's been filled out by Mr. Klein. Mr. Klein received his CPA certificate in 1994. That's certificate number 67451. That license history is at pages 36 to 37. That would be Exhibit 4, Your Honor. His license was surrendered by a stipulation that the board accepted effective May 13th, 2020. An accusation was pending at that time, and the surrender was disciplinary. I'll note that Mr. Klein, in addition to being a CPA, is also an attorney. The facts from which the discipline arose are detailed in the accusation against Mr. Klein. That's at pages 29 through 32 of the packet. That's where you'll see the detailed allegations. And let's see, that would be within Exhibit 3, Your Honor. The discipline arose from Mr. Klein's misconduct in his role as a trustee and financial planner for an elderly man that I'll refer to by the initials HS. That's how the person is referred to in the accusation. Mr. Klein made investments on behalf of HS's trust that were illiquid and undiversified and that were self-serving to Mr. Klein. These investments were poorly managed. He deceived the consumer about what was done with the trust funds. He didn't keep proper records of what he did with the trust funds. He provided false reports to the trustor, and in short, took millions of dollars in a loan type of fashion for his own use. Out of $5 million in funds that he received from the trust, only $8,100 in Mr. Klein's attorney-client trust account was found to be liquid. The investments that Mr. Klein made for the trust were self-serving. The funds were dispersed through loans to 5 different companies that Mr. Klein owned, controlled, or had an interest in. For example, $400,000 of trust funds were loaned to Bay Area Development Company, of which Mr. Klein was the president, and that loan was secured by a vague note that potentially allowed the company to avoid repaying the trust for an unlimited period of time. 2 of the companies that received loans from the trust funds were not in good standing with the state. Mr. Klein prepared false quarterly statements that misrepresented how the funds were invested, and he provided false information in response to the trustor's inquiries. The claimed investments that he had said he'd made on behalf of the trust could not be verified and were not documented. In a probate proceeding after the death of the trustor, Mr. Klein admitted that none of the investments were made in the name of the trust, but the money was invested in his own name, and the trust got no return on those funds. Mr. Klein also made false statements to the board investigator through his attorney, claiming in a letter that he was not the trustor's tax preparer or advisor, when in fact he was involved in preparation of the trustor's tax returns. A probate investigator issued a report which found that Mr. Klein exercised substantial undue influence over the trustor and his wife, and his role as attorney, using his role as attorney, financial advisor, and trustee, and did that in a manner that was not in the best interest of the trust. Based on these acts, the accusation charged Mr. Klein with breach of fiduciary responsibility, knowing preparation of misleading financial information, failure to comply with professional standards, failure to respond to a CBA inquiry, unprofessional conduct, and willful violation. In his petition, which again is at pages 4 to 7 of the materials, Mr. Klein details that he received his Bachelor of Science from UCLA in 1968, his MBA from UCLA in 1969, and his Juris Doctor, his JD degree, in 1971. Mr. Klein claims at page 5 of the materials that the reason for his license discipline is that, quote, opposing counsel did not state facts and my client was killed by his wife, unquote. Your packet contains no narrative or documents that support that statement, which I just quoted. At page 8 of your packet, petition form question number 10 asks why he believes the board should grant his petition. This section is left blank. The only document submitted in support of the petition is a handwritten worksheet summarizing continuing education classes, but that is not supported by any certificates of completion. Mr. Klein submitted no letters of reference. Your Honor, that concludes my summary of the evidence, and I do have some questions for Mr. Klein once he's concluded his presentation on the petition.
Very good, thank you. So Mr. Klein, even though I cannot see you and you cannot see me, if I could have you raise your right hand, please, and I'll swear you in.
Yes.
Do you solemnly swear or affirm under penalty of perjury that the testimony you will provide in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you may put your hand down. If I could have you start by stating and spelling your full name for the record, please.
Leslie Klein, Leslie Klein.
Okay, Mr. Klein, just wanted to remind you again that what the board is most interested in hearing about is any rehabilitation you have undergone since your license was disciplined. With that reminder, whenever you're ready, you may begin.
Well, I have taken some courses on ethics with the State Bar, and as the Attorney General, Assistant Attorney General said, I've been in practice of law and accounting since for the past 50 years, and I never had any complaints against me in front of the accounting board. And I practice law. I really don't do much accounting. I don't actually prepare tax returns. And I have really not used my CPA license for the last 50 years. But I was represented by counsel, and the reason why we accepted the deal that we were offered by the Attorney General is because my counsel advised me that once I give up my license, I will be applied in a year and the license will automatically be renewed. So that's why we entered this stipulation. We didn't fight the allegations. We didn't do anything, although I think we had a very, very good defense. And at the time that the case was going to trial, we had submitted letters from other accountants saying that, I was part of the community and, I was a good guy. So that's all I have to say.
Mr. Descartes, cross-examination.
Yes, Mr. Klein, you just said that you could have put on a very good defense, but you did decide to relinquish your right to dispute the allegations in the accusation against you. And
That's
so
correct.
I'd like to know what, if anything, did you do wrong in regards to the trust of HS?
Well, if I would have gone to trial, then I would have told the court or the trial of facts that HS, Hubert Scott, was my client for the last 25 years. I represented him in all kinds of matters. He was an engineer working for Lockheed. His son was killed in an accident at LAX, and they got quite a bit of money. And his wife wanted to take away his money. And basically I advised Mr. Scott and his wife that this was a separate property, it wasn't her money. And then Hubert Scott decided they didn't want to give his wife any money at all. And they started fighting and whatever. But I really don't want to go into the facts of Hubert Scott because I feel very, very strongly that Hubert Scott was railroaded by his wife. She filed a conservatorship for him to be appointed conservator for him, but he was never physically examined. She held him as prisoner in his house, whereby he couldn't talk to anybody. The only person he was able to talk to is me, because I would go to visit him. But again, I really don't want to go into all the details of the case of Hubert Scott. And all the monies that I invested for him were invested pursuant to his request. I didn't invest anything that he didn't want to be invested in. And the monies were invested in insurance policies, and those insurance policies, when the individuals pass away, will pay off. And so it's not true that I lost his money. It's just not true at all.
Mr. Klein, do you admit doing anything wrong as alleged in the accusation against you?
Well, I'm not going to go over the case. I mean, obviously my attorney, who's a very good attorney, his name is Mr. Dean, thought that the best thing to do here was not to go to trial, but to just enter into a stipulation. And that's what I did. I followed the advice of Randall Dean, my attorney, and basically I did what he told me to do.
Did you invest trust funds in companies in which you held an interest?
The answer to the question is there was one trust fund, Beta Development Company, which I invested money in. But again, this was done with the express permission of Hubert Scott.
Have you done anything to rehabilitate yourself since you surrendered your license 2 years ago?
Well, I don't basically deal anymore with clients. I don't at all invest any monies for clients, which I really, have not done. And basically, I don't get involved with managing clients' money. I just basically practice law. I don't use clients' money. I don't talk to them about investments. I have totally gotten out of the business of advising clients about investing their money with anybody, including me.
What is the nature of your practice, and what would you want to do with your CPA license if it was given back to you?
Well, my practice is I'm a lawyer. My specialty is basically probate law, and I handle will contests. If somebody prepares a will and there was undue influence or what have you, I go to trial and prove that either the will is valid or the will is not valid. I also do trust for people, a living trust, whereby if the person, instead of doing a will, where in a will you have to go to probate court, if you do a trust, you avoid probate. And basically that's what I do. Is I'm also getting on in years, over 75, and I'm taking it easy. I really don't work full time. I only work like half of the time. And as far as using my CPA license, I really don't think I'm going to use it. But in this area that I litigate, the area that I do review tax returns, I do review, estate tax returns, and basically that's what I would use my CPA license for, is to review tax returns, 706s.
Your Honor, those are all the questions that I have for Mr. Klein.
Thank you. Mr. Klein, is there anything else you wanted to say on your behalf before the board asks questions?
No, I am ready for the board's questions.
All right, Ms. Reed, if you would like to go through the board to elicit any questions, please.
Yes, thank you. Thank you for being here, Mr. Klein. Just a couple of questions. So when, as you say, the client was directing you on how he wanted his funds invested, were you discussing risks and liquidity and consideration also of his age, his position in life?
Yes, I did. And he was a very sophisticated client. As I say, he was an engineer at Lockheed. And I did tell him that it's risky. In other words, he had money sitting at the Lockheed Credit Union whereby he's earning less than 0.5%. And they said that he wanted to at least earn 6%. and he was willing to take some risk. And he kept some money at the credit union too. And as I say, he was very, very sophisticated. He knew what he was doing. But I certainly discussed that with him. Yes.
Okay, thank you. And at this time, and another question, Mr. Klein. So at this time here, as we sit, has the client or his estate, I should say, been made whole for these losses, or is that just those are just lost funds?
Well, no, the funds are not lost. The estate, well, he is dead, and his main beneficiary was his son and grandson, who are the beneficiaries of 80% of his estate. His son recently passed away, and the grandchildren are now petitioning to be appointed administrators for the son's estate. And the funds that, once they're appointed the administrators for the estate, they will receive the bulk of the funds.
Okay, thank you, Mr. Klein. No more questions.
Thank you.
Carrie Ann Farrell-Hines. Dan Jacobson.
No questions.
Dee Dee Owens. Katrina Salazar.
No questions.
Michael Savoy.
Questions. I see that this complaint was submitted by his wife, his ex-wife, I guess.
Yes.
Was she the trustee of the trust? Because you're mentioning
yes, she
that
was.
She was.
He was the trustee, yes.
So even
Actually,
though
no, I take that back. I'm sorry. He was the trustee of this trust. She was not the trustee. He was the trustee of his trust.
So even though his son and then his grandson are beneficiaries of this trust, why is it that she took it upon herself to sue you for embezzlement when she would not have any privy to this money anyway?
Well, she has a small percentage. She has, I think, 10%. And you're right. The person who really should have sued me was the son and the grandson. But obviously, the son and the grandson didn't think there was a case. Also, she filed a complaint to the state bar, and the state bar dismissed the complaint. They never did anything.
Okay, so I'm trying to follow up also on Ms. Corrigan's question about was the estate or is the estate made whole at this point in time from the original monies invested?
Well, the state will be made whole at the time when the people that the policies were purchased for pass away. And some of these people are fairly old. One of them has cancer. With that person's life expectancy is maybe a year or two. And so when these people pass away, yes, the state will be made whole, yes.
Okay, but at this point, they're not.
That is correct. At this point, they are not.
Okay, how much money? Looks like there was, what, 2.4 million of the 5 million has been recovered so far?
Yes, I think there was 2.4 million recovered. I think there's 1 million missing. And one of the policies has been sold, and so you don't have to make any payments. So that means that when the person dies, this estate is guaranteed $1 million, and the state doesn't have to make any more payments on that policy. And the person who is going to die, that person has cancer. So I don't think that's a problem.
Well, I see that, but you spent $500,000 to purchase a $5 million policy, another $500,000 to purchase another $5 million policy. So is it true that this $1 million invested in life insurance at some point will turn into $10 million?
No, it's not true it's going to turn into $10 million because the $500,000 was paid in premiums, and the $500,000 is going to come back. So there's going to be $1 million coming back, not $10 million coming back.
Okay. So, I mean, I'm looking at the allegations, and It's a little misleading. No further
Okay.
questions.
I'm sorry.
Thank you.
Thank you.
Mark Silverman
No questions.
and Yen Tu. Thank you.
All right. So, Ms. Reed, is that the entire board?
Yes, it is, Your Honor.
Thank you. So next, thank you, Mr. Klein. You're excused as a witness. And next,
Thank you very much.
You're welcome. We will proceed to closing arguments. Mr. Descartes.
Mr. Klein's misconduct was very serious. Besides the $1 million allegedly spent to buy life insurance policies, there was another $4 million apparently. If you look at paragraph 23 of the accusation, which is on page 32 of the materials. And it appears that that money was primarily used to invest in Mr. Klein's own companies. And it's also alleged in the accusation that HS, prior to his death, was a demented individual. So though he may have been sophisticated at one time in his life, the allegations in the accusation are that he suffered from dementia by the time of his death. And on these facts, it appears that Mr. Klein took advantage of an elderly consumer by lying about how the funds were invested, providing false reports, failing to document what was done with the funds, and underreporting the amount of funds received. So it's troubling that at this point, Mr. Klein is basically denying wrongdoing when he did agree to surrender his license and chose not to fight these allegations. He's basically saying that he didn't do anything wrong and that he wouldn't have anything to rehabilitate for. But his petition lacks basic support. He doesn't provide evidence in support of his claims. And of course, there's no evidence of rehabilitation, no reference letters, no showing of community service or anything like that. And the petition I believe it's page 5, even blames his discipline on other people. And so the decision that a board makes on a petition for reinstatement, it's been framed by an appellate court this way. Has a petitioner coupled his acknowledgement of wrongdoing with sustained exemplary conduct over an extended period of time, which may be viewed as a true indication of rehabilitation? That's the case of In Re Mena, MENNA, a 1995 case, 11 Cal 4th, 975 at page 991. Going by that standard, a little time has passed since Mr. Klein surrendered his license in 2020. He doesn't acknowledge wrongdoing, and he offered no evidence of exemplary conduct since his surrender. Therefore, it is contended that it would be detrimental to public protection if he got his CPA license back when he has not met the burden of demonstrating rehabilitation. Thank you.
Thank you. Mr. Klein, your closing argument, please.
Yes, well, I think the Attorney General is totally wrong. Basically, I have decided that I'm not going to do at all this kind of practice. I am not at all going to talk to people about how they want to invest their money. I don't think that Mr. Uberscott had dementia. He was very, very sophisticated. So my answer is I think I've rehabilitated. I don't do this anymore. And I would like my license back. I mean, all these years, I've been practicing as an accountant for 50 years plus. I never, ever had a complaint. And basically, I stipulated to surrender my license because I was told by Mr. Dean and by the person handling this case for the Attorney General, I think, I don't remember his name, but be that as it may, that if I basically decide, if I make a decision that I'm never going to do this anymore, I'm not going to invest people's money, I'm not going to do anything anymore, I'm just going to concentrate on doing law, then there wouldn't be a problem that I would get my license back. So I leave it up to you what you want to decide.
All right, thank you. So that concludes the hearing. The record's closed, the matter's submitted, and we're off the record. And Madam Court Reporter, if I could get a page estimate.
I'm going to say 40 pages.
40 pages?
Yeah, do you need an end time?
I have 2:13. Okay, and so Mr. Klein, what happens now is after the board hears the second petition matter, it will adjourn to closed session to discuss the two petition matters, and it will make a decision during closed session, but a decision will not be issued today. Rather, it will be issued at a later date by writing, and you'll receive a copy in the mail.
Thank you very much.
You're welcome. And then the other thing is, if we were here together in person, I would be providing you with a court reporter billing sheet that provides information for you in case you want to order a copy of today's transcript. But since we're not in person, I will have my office send that to you. And so when you get that, that's just so you know what it is. It's just in case you want to order a copy of the transcript. All right. So that concludes the hearing. You're free to leave. Thank you for your time.
Thank you. Bye.
Okay, Mr. President, shall we proceed to the next matter, or does the board wish a break?
Forward, please.
Okay, so let me switch my matters. All right, Madam Court Reporter, are you ready for the next matter?
Yes, I'm ready.
All right, so let's go ahead and go on the record. So we are back on the record before the California Board of Accountancy, Department of Consumer Affairs, State of California, in the matter of the petition for reinstatement of restricted area of practice by Timothy, middle initial A as in Adam, last name Coons, C-O-O-N-S. It's OAH number 2022-020048. My name is Quorum Wong. I'm an administrative law judge with the Office of Administrative Hearings, and I have been assigned to preside over this matter with the board. In order to establish a quorum of the board for the record, I'll ask Ms. Reed to call roll call and for each member to respond audibly after his or her name is called. Ms. Reed?
Nancy Corrigan. Carrie Ann Farrell Hines.
Present.
Dan Jacobson.
Here.
Dee Dee Owens. Katrina Salazar.
Present.
Michael Savoy.
Present.
Mark Silverman. And Yin Tu.
Present.
We have a quorum.
Thank you. And next, if I could take the appearance of counsel, starting with the Deputy Attorney General.
Ted Durkar, that's spelled D-R-C-A-R, Deputy Attorney General, appearing on behalf of the people of the state of California.
Good afternoon.
Good afternoon, Your Honor. Kevin McLaughlin, appearing on behalf of Petitioner Timothy Coons.
Good afternoon. And Mr. Coons, I want to make sure that you could hear me okay?
Yes, sir, I can hear you.
Very good. Mr. McLaughlin, are you familiar with the procedural process for these hearings?
Yes, Your Honor.
Okay, very good. I didn't want to explain something you already knew, but I didn't want to assume you knew and then not explain if you didn't. So, Mr. Durkar, if you'd like to provide your summary statement or documents, whichever you prefer first.
Yes, Your Honor. I'd like to present the documents first. The board members and petitioner have been provided with a copy of the same petition packet with sequentially numbered pages. There are 98 pages, and they're marked TAC-PET001 through 98. That includes the notice of hearing at page 97. I would like to mark the entire packet and offer it into evidence.
All righty, thank you. So Bates numbers 1 through 3 will be marked as Exhibit 1 for identification. Mr. McLaughlin, any objection to 1 for all purposes?
No, Your Honor.
Thank you. And then Bates 4 through 71 will be marked collectively as Exhibit 2. Mr. McLaughlin, any objection to 2 for all purposes?
Only, Your Honor. Are we alphabetical or numeric? Is it Exhibit B or Exhibit 2?
2. I'm sorry, did I say B?
No, 2 is fine. No objection, Your Honor.
Yeah. All right. So, and then Exhibit 3 will be Bates 72 through 94. Any objection to Exhibit 3?
No, Your Honor.
3 is so admitted. And then Bates 95 through 96 is marked as Exhibit 4. Any objection to 4 for all purposes?
No, Your Honor.
4 is so admitted. And then last, Bates 97 through 98 are marked as Exhibit 5. Any objection to 5 for all purposes?
No, Your Honor.
5 is so admitted. Thank you. Mr. Descartes, if you'd like to provide your summary.
Yes, thank you, Your Honor. I'll provide a summary of the petition and the evidence in it. The certification of license history for Mr. Coons is Exhibit 4 at pages 95 to 96. He was first licensed as a CPA in 2003. At pages 73 through 94 of the packet, which is Exhibit 3, is the board's 2016 decision and order. It adopted a stipulated settlement and put Mr. Coons on probation for 3 years and imposed a permanent practice restriction from doing a test work. Now, Mr. Coons has completed his 3 years of probation. He did so back in 2019, and now he's appearing before you today seeking to end that practice restriction so that he could do a test work again. The accusation is at pages 83 to 94. Mr. Coons admitted all the allegations in the accusation in his stipulation. And that accusation contains 7 causes for discipline. It was based upon discipline that had previously been taken by the Public Company Accounting Oversight Board, known as the Pcaob. That willful violations of the Accountancy Act and a board regulation. There was also a cause for discipline for practice under a fictitious name while not registered with the board. Failure to comply with peer review was another cause for discipline. Failure to notify the board of failed peer review. And finally, failure to respond to board inquiries. To provide a little background behind those causes for discipline, I'll provide a summary of the evidence. The Pcaob disciplined Mr. Coons in 2015 with an order that censured him and imposed a $7,500 fine for his failure to comply with Auditing Standard 7, which is in regards to engagement quality review. This lapse occurred in audits for 2 clients. Mr. Coons practiced accounting through an unregistered fictitious business name, the Tax Doctor, which wasn't registered with the board or with the Secretary of State. This practice was a sole proprietorship, and his website advertised that his services included audits, reviews, compilations, and public company accounting. The following facts, which I'm about to detail, appear at pages 89 through 91 of the materials before you. Mr. Coons failed to submit his PR1 peer review reporting form as required back in 2012, even after multiple notices that started in 2011. In 2013, he was cited for failing to respond to inquiries from board staff. He paid the $250 citation fine, but failed to comply with the order of abatement, which called for him to submit the missing PR1 form. He also failed to undergo peer review that was required, given the nature of his practice. It wasn't just that he needed to submit the form, he actually was obligated to go through peer review. In December 2012, he submitted a PR1 form that said peer review was in progress. Going forward into 2013, he failed to respond to inquiries from board staff about his failure to report acceptance into a recognized peer review program. Then in 2014, the board staff opened up an enforcement case to investigate his failure to complete mandatory peer review. Mr. Coons failed to respond to an investigative inquiry. For the license renewal period ending in January 2015, Mr. Coons submitted a renewal application that attached his 2012 PR1 form, which falsely stated that peer review was in progress. And he wrote on the application that peer review, he claimed that peer review was in progress, which didn't happen until much later. He was aware that he was subject to peer review requirements and that he needed to undergo peer review before renewing his license. Once he did get peer review in March 2015, a report from the Cal CPA peer review program stated that Mr. Coons failed peer review, and then Mr. Coons failed to notify the CBA of his peer review failure. So that's the background and the reason for his discipline. His petition for reinstatement is at pages 6 through 11 of your packet. His disciplinary order included a permanent restriction from a test work. And so now he's asking that he be restored to a test work. His answers to the questions in the peer review form that call for narrative answers, those narrative answers are on pages 70 and 71 of your packet. Some of you may have missed that because it's a little difficult. His petition's back near the top of your packet, and those narrative answers aren't until pages 70 and 71. So looking at those narrative answers, Mr. Coons details some facts that I'd like to summarize. Mr. Coons successfully completed his 3-year period of probation, as I mentioned earlier, from 2016 to 2019. And he paid the board's costs as ordered and agreed. His petition refers to that as payment of restitution. We would typically call those costs. And just to clarify, he wasn't ordered to pay restitution to any consumers. He was ordered to pay costs of investigation and enforcement, and he's done so. Mr. Coons claims that he complied with all requirements in the Pcaob disciplinary order. And explains that he resigned his registration with the Pcaob, and he claims that he will not do public company audit work in the future, the type that is governed by the Pcaob. In explaining why the petition should be granted, Mr. Coons wrote that he is fully rehabilitated because he never had any intent or negligent disregard in his prior conduct, and nobody was harmed by it. However, as previously stated, he did admit to willful violation in his stipulation to resolve the disciplinary case. He claims that he fully cooperated with the board's investigation of his offenses. However, the accusation that he emitted does detail his failure for several years to cooperate with board inquiries. However, that is from the period of 2011 up through perhaps 2015. There's no report of a repeat of that behavior since then. He is aware of his violations, he says, and he claims he will follow the rules and regulations in the future. He notes that the IRS did not take disciplinary action against him and that he has no other discipline or investigations pending against him. I would like to detail something significant at paragraph 71 that I will I expect to question him about later if he doesn't cover it first himself. On page 71, in response to question 10 in the petition form, he wrote that, referring to himself, it says, meanwhile, the petitioner has made considerable efforts to maintain and/or upgrade his professional skills and knowledge through continuing education and other methods, which are ongoing to this very date. He has taken efforts to establish safeguards to prevent repetition of the original violation, including changes and modifications in policies, structure, systems, and methods of behavior applicable to his accountancy practice. The petitioner has provided additional pro bono services to community and charitable groups, nonprofit organizations, and public agencies. Then going forward, near the bottom of the page, in response to question 11 about his practice plans, he says he does not do audits, but he's seeking relief here through his petition because he does want the ability to do reviews and compilations. The documents that Mr. Coons submitted in support of the petition are at pages 13 through 69 of your packet, and they include the following. There are live scan records, continuing education records, and there are summary sheets claiming 105 hours from 2015 to 2018. That's at page 23. And then there, further on, there is a worksheet claiming that he took 86 hours of continuing education courses in 2019 and 2020. He submitted a report from the Cal CPA peer review program dated November 7th, 2018, showing that he passed peer review that time. And at pages 67 to 68 is a letter of recommendation dated February 16th, 2021 from CPA Louis Tomasino, the CPA who originally sponsored Mr. Coons for his license. And it appears that he also supervised the work of Mr. Coons as a CPA. Mr. Tomasino praises Mr. Coons for being a talented and able accountant who can deal with complex accounting issues. Mr. Tomasino vouches for Mr. Coons' trustworthiness, character, and judgment in accounting. And it appears Mr. Coons did work for Mr. Tomasino's firm. The letter says that Mr. Coons is responsible, detail-oriented, and that his work was valuable to the Tomasino firm. So that concludes my summary of the case. And Mr. Coons now has the burden of proof, and I will have some questions for him once he's done with his case in chief. Thank you, Your Honor.
Thank you, Mr. Descartes. All right, Mr. McLaughlin, do you have any witnesses you wanted to call other than Mr. Coons?
I believe Mr. Louis Tomasino is online as an attendee at this moment. We intend to call him later.
Okay, and did you have any other documents or any additional documents you wanted to offer in addition to what Mr. Descartes offered?
No, Your Honor.
All right, and did you wish to call Mr. Coons first?
Yes, Your Honor.
All right, Mr. Coons, if I could have you raise your right hand, please. Do you solemnly swear or affirm under penalty of perjury that the testimony you will provide in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may put your hand down. If I could have you start by stating and spelling your full name for the record, please.
Timothy Allen Coons, Timothy, name Allen, Alan, last name Coons, Coons.
Very good. Thank you. Mr. McLaughlin, whenever you're ready.
Thank you, Your Honor. Mr. Coons, it's my intent this afternoon to ask you a few questions regarding the earlier matter of which your discipline arose, in which you successfully completed your probation in 2019. My point is not to relitigate or readdress all of that underlying activity, but more so to give His Honor, Deputy Attorney General Descartes, and the ladies and gentlemen of the board an opportunity to understand what transpired in the past and compare that to what you have admirably conducted yourself today. So, Mr. Coons, the first thing that I'd like to ask you questions about is the allegations against you regarding the use of the tax doctor. Do you recall using that fictitious business name?
Yes, sir.
When did you first start using that and why?
Probably around 2008, 2009, because I had received my doctorate original certificate back in 2007. So I was doing taxes and I had a doctorate, so I used the name tax doctor.
And you acknowledge that you did not register that fictitious business name with the Board of Accountancy as required, correct?
Yes, I did not. I failed to register that.
And have you ever acted or operated as a fictitious business name, the tax doctor, since these allegations?
No, sir.
Do you believe that that was willful or intentional on your part, as not registering?
I admit I should have registered it, but I was not trying to use it in any harmful or misleading manner.
Let me ask you another question on that, Mr. Coons. Why did you not register it to begin with?
I didn't. It just slipped my mind. I didn't think about it, and so I don't intend on using it, and it's no longer a valid option.
Mr. Coons, the second kind of grouping of allegations levied against you is in regard to peer review. Are you aware of those allegations?
Yes, sir.
Do you deny them?
No.
Can you explain to myself, His Honor, the Deputy Attorney General, and the ladies and gentlemen of the board, why you were originally non-responsive to the Board of Accountancy when they asked for information about your peer reviews?
The initial peer review, I was financially incapable of being able to really perform it, and so I was trying to seek other options to procure a peer review. And in 15, when I was working on trying to get the peer review done, there was conflicts between AICPA and CalCPA as to who was to issue the authorization for assigning a peer reviewer, and it became muddled, and so it was difficult.
So in addition to, Mr. Coons, could you elaborate on in addition to what I understood is the financial difficulties, you said there were some complexities between CalCPA and the AICPA. Could you explain and elaborate on that a little bit more?
Well, because of the broker-dealer audits requiring a systems review and also has to be approved through AICPA through their portal, I was trying to get the portal, and then CalCPA was saying that they didn't receive it. And then I contacted CalCPA and then AICPA, and until finally we got it worked out so that I could actually engage a peer reviewer to handle the peer review.
And Mr. Coons, you actually have successfully completed peer reviews, correct?
My last peer review was one audit and one review, which there was only 2 engagements prior to the restriction on my license, and they were passed with no deficiencies.
Do you recall, or I should say, was that the 2018 peer review that the Deputy Attorney General mentioned earlier?
Yes, sir.
Mr. Coons, I want to ask you now kind of the third grouping of allegations that were originally levied against you, and that involves the Pcaob disciplinary action. Are you familiar with that?
Yes, sir.
Can you please describe to His Honor and the members of the board what transpired as to why the Pcaob rendered disciplinary action against you?
They performed an inspection on 2 audits, but I had requested from the attorney that had hired me to perform the audits to withdraw the audits as requested, because they're supposed to have requested a withdrawal, but because they didn't, they performed a internal inspection. I failed the inspection on the part of understanding third-party involvement, which the attorney who hired me did not disclose, and I should have done more due diligence, which caused me to be sanctioned because of the failure of due diligence within the audit realm on the two audits.
So the two audits, Mr. Coons, is that box receipts and off-site docs? Are those the two?
Yes, sir.
How many up until this period of time? How many audits did you actually perform?
Prior to those two audits, I had performed broker-dealer audits annually, roughly about 3 of them, which were successfully examined by, they didn't note that those were in any deficiency. However, on my failed peer review, there was a deficiency on that one of the broker-dealer audits, which was on the peer review, but not reviewed by Pcaob.
So let's Mr. Coons, let's address that. Could you describe then what deficiency peer review found?
It was in documentation, internal documentation on audit documentation, not necessarily in figures or analysis or anything that would mislead any SEC or FINRA in regards to the health or viability of the broker-dealer.
I'm going to go back, Mr. Coons, though, and address the two underlying audits that caused the PCAOB discipline. That's the off-site docs and the box site examinations. You, as I understood, you said that you issued audit opinions, correct?
Yes, sir.
Okay, and then you indicated that you asked them to be withdrawn?
Yes.
And who did you ask them to be?
The attorney who had hired me.
And were they willing to do so?
I never heard back, so that's when I thought they had been withdrawn. But when the PCAOB inspection came, those were the only 2 that were inspected. So there was a third one that was withdrawn successfully, and somehow I don't know why the other 2 weren't withdrawn, because I specifically sent a withdrawal of engagement to the attorney regarding those two audits.
Mr. Coons, did the PCAOB ever make allegations that you had harmed any investors or caused damage to the public as a result of those 2 audits?
No, sir. It was from failure to document internal controls and third-party items.
So no investors or public members of the public were injured. Is that correct?
Yes, sir.
One of the conditions, Mr. Coons, of your PCAOB discipline was a $7,500 fine. Is that correct?
Yes, sir.
Did you pay that?
Yes, sir.
You also voluntarily resigned your registration with the PCAOB. Is that correct?
Yes, sir.
Do you intend to perform any professional services that would require you to re-register with the PCAOB moving forward?
No, sir.
Mr. Coons, can you describe what your practice has been like since the discipline of this board in 2016?
It's been limited to tax and tax practice, preparation for tax returns, prepared statements, and bookkeeping.
And you have successfully completed your probation, correct?
Yes, sir.
One of the conditions of your stipulated settlement with this board was to pay a fine of approximately $9,000, or I should say reimburse the board approximately $9,000. Do you recall that?
Yes, sir.
Did you do that?
I paid it off 9 months early.
Not only did you pay it off, you paid it off early, correct?
Yes, sir.
Okay. And you've been preparing tax returns largely since then. Is that accurate?
Yes, sir.
As the Deputy Attorney General pointed out, we have put forth in your petition as some rehabilitating factors what you have done since the discipline to increase your professional skills and knowledge. Can you describe to His Honor and the members of the board what you have been doing to increase your professional skills and knowledge since the discipline in 2016?
I have maintained enough professional education under A&A, fraud, and everything to stay up to date on the current accounting standards and AICP standards for audits and compilations, as well as understanding the new requirements under prepared statements and everything that have come in within the past couple of years. And I've maintained also my ethics courses, even though I wasn't required to do a regulatory ethics course every renewal. I have done so, as well as the standard ethics course required for renewal. So to show and everybody that I maintain my standard of ethics and that I am not a danger to any public or private entity or individual.
And what have you done, Mr. Coons, if anything, to change your policies, structure, systems, and methods of behavior in the practice of public accountancy?
Because I can't do attestation functions, I still, even when taking on tax returns or other things that are highly complex issues, if I don't feel that I have sufficient understanding or wherewithal, I will turn it down and not even perform those tax preparation services because of the nature. And so I look at anytime I vet new clients so that I make sure that that they meet my standards of ethics as well as the public's in the public side. What I do is so that I don't put something out there that is in violation of any tax code, in violation of any state tax code, or ensure that when I do accounting or tax preparation or bookkeeping for individuals, that all of these statements are issued under the current standards, and I analyze them so that they meet the standards required under the current AICPA and accounting codes.
Mr. Coons, is this level of due diligence something that you exercised before the stipulated settlement in 2016?
No, I did not before. So this would be part of my rehabilitative process, that I vet my clients before I take them on anymore.
And could you describe your community involvement services and activities?
I give to several charities. I'm a disabled veteran myself. So I give to the Disabled American Veterans Association. I also help veterans out in reducing how much I charge veterans or active duty military for their returns, so they can still, if they're on deployment, be able to afford a professional service instead of some of the free services that are offered. I serve it at a complete discount. I also have done walks for charities and raise funds for charities because some of my clients have children like with autism or cancer. So I personally, empathize with my clients and help them, as well as help my community to see these things and hopefully get cures, or at least provide assistance for those who need that kind of assistance.
So, Mr. Coons, what I'm hearing is part of your pro bono services, you provide income tax services to other veterans free of charge?
Not totally free, but like just minimum e-file cost, $10, $15 versus whatever something else does.
I understand. And you have not continued to perform any audits, reviews, compilations, or other test services since your stipulated settlement. Is that correct, Mr. Coons?
That is correct, sir.
Thank you, Mr. Coons. And Your Honor, nothing further right now.
Thank you. Cross-examination?
Thank you, Your Honor. Mr. Coons, could you tell us about your experience in working for the firm, the Tomasino firm?
Yes, I met Mr. Tomasino back in 1997 and started consulting with him in 1998. I have been a asset with his firm for over 20 years. And he has been a mentor to me, as well as certain things where I've been a mentor to him. It's a family soul business for him and for me, and he recognizes my valuable input and ethics, and I take the same thing from him. And so we have a great relationship that we have developed over the years, that we trust each other's judgment, and we have a means of support for each other, so that we understand where, if there's something that comes up on his side of the business and that I've had experience with, we discuss openly, and the same thing vice versa. So he's fully aware of things that certain aspects of my business, and I'm aware of aspects of his. We haven't really merged our practices because we've had this agreement for so long, but he has provided me backup, and I provided him backup when he was disabled for a while. So we have provided each other a means of second review between businesses and business practices.
All right, I want to clear something up. My understanding was that you'd actually worked for him as an employee or an associate, but is that not the case? Were you just peers?
I am an associate of his firm. Yes.
Okay, and how many years have you worked for his firm? Over what time frame?
From 1998 to current.
In regards to the allegations that which you admitted about ignoring correspondence from board staff over a period of years, can you explain why you failed to respond to so many board inquiries?
I was in financial hardship. I'd gone through a divorce back in 2008, and I was still recovering from lack of financial support because my business wasn't that extensive during that time period. And I was having difficulty because I had to move around a lot, keep moving until I finally was able to secure a adequate, living aspect of it. And then trying to maintain the business and my son and everything. A lot of it ended up being on the personal side, not so much the professional side, but it affected the professional side, which I admit, I should have come across and discussed that with the board. But in future aspects of it, I have tried to prove to the board and all its members and to everything that I'm following all the guidelines, and I don't intend to deviate moving forward from at all.
Yeah, you mentioned that you had hardships in the past, and you've described them, and trouble can still come up at any time in a person's life. Are you prepared to cooperate with the board's oversight of your practice, even if you have major personal issues and troubles in your life in the future?
I have kind of eliminated almost all the external aspects. The only thing that could potentially happen is if I personally get sick and am unable to perform, which would basically be, putting me in the hospital or something. Other than that, I have eliminated all the other outside interference issues within my personal life at this point.
Do you believe that you're ready to meet all of the professional standards related to attest work?
Yes, sir.
And I, at the risk of retreading on some ground you've covered already, in addition to the continuing education coursework that you've submitted, that you've demonstrated, what have you done to prepare yourself to do attest work once again?
I've maintained a all my continuing education and stayed up to date. I have access to the PPC most current versions, so I am well aware of the changes, and I continue to do my ANA continuing education to ensure that I stay on top of the more current requirements and reporting standards, both on BOA, tax, cash basis, GAAP, so that if I issue reports in the future, they are all up to guideline and will pass a peer review.
Have you had any exposure to that work in recent years as an employee?
Not as an employee, but as a consultant for Mr. Tomasino. His last peer review showed that the work that I consulted on, a review and a compilation, passed without any deficiency on those two items within the past 2 years.
All right, thank you, Your Honor. Those are all the questions I have for Mr. Coons.
Thank you. Mr. McLaughlin, anything further on redirect?
No, Your Honor.
All right, Ms. Reed, if you would like to poll the board for any further questions.
Nancy Corrigan,
Thank you. No questions?
Carrie Ann Farrell Hines,
Thank you.
Dan Jacobson.
Yes, just one moment, please.
Thank you.
Mr. Coons, I know that you're here as a fact witness and not an expert, but I'm going to ask this anyways, and hopefully you can help me out somewhat. On page 71, at one point, you or your attorney writes that the petitioner does not intend to perform any attest engagements requiring registration within the Pcaob governance. And then just about 3 paragraphs down, it says the petitioner wishes to continue his tax practice, does not wish to perform attestation engagements for any audits. However, he wishes to perform attestation engagements up to reviews and compilations in the future. What is it that you would not be able to do by not being a registrant of the Pcaob, at least as you understand it?
As I understand it, any compilation, review, or audit that from a publicly traded, whether it was Reg A, Reg D, or any broker dealer in any form of financial compilation, review, or attestation engagement that would require Pcaob oversight. So those would be excluded from my practice.
Thank you.
Patty Bowers, I am so sorry to interrupt. Could we just take a moment to check on the court reporter to make sure everything is okay?
Madam Court Reporter, are you still with us?
Sure.
And everything, did you lose anything?
I did not, but I don't see my
I don't see my screen up there, but it says when I hit start video, it tells me it's already in use. So I'm assuming you guys can see me.
I cannot. We actually show you connected twice.
I don't know how that happened. I'm also echoing.
It's probably because it's
but you guys sound fine to me.
Right. It's probably because you're somehow connected twice.
I don't know how you're not. Because I see my name over here on the list. But
Okay.
I haven't. But I've been here the whole entire time.
Okay. So as long as you could hear.
I can hear you guys fine. I just don't know. It tells me to another application using my camera, but I don't know how that happened. I logged on once.
Okay. All right. Let's go ahead and continue.
Okay.
One more question, if I may, Mr. Coons. For the Pcaob governance issues that you had in the past, what is your feeling about that now? Are you sorry about it? Do you think that you were wrongly accused? What?
I felt that I felt that in there, I didn't think about obtaining legal counsel, which it may have been mitigated. But at the time, I felt pressured, and I had no other alternative at the time. So, and the fact that the attorney who had hired me was a third party when it wasn't disclosed, and when the Pcaob disclosed it in their review of the documentation, I was shocked, and I didn't know how to defend myself and how I could get out of it to assure them that there was nothing that I did that was to harm anybody, and that this individual who was an attorney, had misrepresented herself as well, and that I had requested the redaction of and retraction of the engagements, but that was never done. So then I could never contact that person afterwards. So I was at a loss, and I only did what I could do just to save face. And I know I should have reported it to the board. In hindsight, 2020, it was a difficult time.
Thank you very much. No more questions.
Owens?
I have no questions.
Katrina Salazar? Michael Savoy?
One question. If we give you back your attestation minus audit, how would you feel about that?
I can do that.
Because you're asking for everything except for that. So I just want to know if it's something that you could work with.
Yes, sir.
Thank you.
Mark Silverman?
Question. What did you say about your PhD, and what subject was it in? I didn't quite get it when you described
International tax.
Thank you.
Yen Tu?
No questions.
Right, Your Honor, all the members have polled.
So, Mr. Coons, you're excused as a witness. Mr. McLaughlin, would you like to call your next witness?
Yes, Your Honor, and I will be brief if I can. Is Mr. Louis Tomasino still online and available?
I believe he needs to be elevated. Whoops, I actually don't see him listed anymore.
Moderator, I apologize for interrupting. I have promoted Louis. I don't have a last name, but I can send a request for Louis to unmute.
All right, Mr. Tomasino, can you hear me?
Yes, I can.
Okay, if you would raise your right hand, please. Do you solemnly swear or affirm under penalty of perjury that the testimony you will provide in this matter will be the truth, the whole truth, and nothing but the truth?
Absolutely, I do.
Okay, you may put your hand down. If you would start by stating and spelling your full name for the record, please.
Yes, my name is Louis, Louis, Tomasino, Tommasino.
Very good, thank you. Mr. McLaughlin, whenever you're ready.
Thank you, Mr. Tomasino. This matter that you've been asked to be a witness in involves Timothy Allen Coons. Are you familiar with that individual?
Yes, I am.
And can you describe how it is that you know Mr. Coons?
Well, I met Mr. Coons through my mother-in-law, Janine Lacey, who was a teaching assistant at Claremont High School. So at that time, Mr. Coons was a teaching assistant in high school. He was studying he was studying for the CPA exam and was referred to me by my mother-in-law as someone who could assist my practice in tax preparation. And I come to find out that he was working for his father-in-law, who had worked for one of the big 8 firms, and he had audit experience. So I appreciated the fact that I could, as I was starting my practice here in San Diego, I could find a resource such as Tim, and that's how I met him.
And I'm sorry, Mr. Tomasino, you too are a licensed CPA, is that correct?
I am a licensed CPA in the state of Arizona and the state of California.
And how long have you been a licensed CPA in both the state of Arizona and the state of California?
I've been a licensed CPA in Arizona since 1991 and a licensed CPA in California since 1996.
Thank you, Mr. Tomasino. And did Mr. Coons actually come to work for your firm?
He works with us as a consultant and as an advisor as well.
And can you give us a time period of which Mr. Coons has worked as a consultant and advisor with your firm?
He has been working with us since 1998.
And in working in this capacity, could you describe a little bit, Mr. Tomasino, what Mr. Coons' duties, jobs, roles, and responsibilities are?
Certainly. He provides advanced tax work for our clients in the areas of estate and international tax. He's consulted with me on financial statements as regards to updates on FASBs, and financial statement presentation. And when our firm goes through peer review, he works with me and our team to ensure that the peer review is being prepared properly. He has also advised our clients on advanced consultations such as business valuations, IRS and FTB problem resolution representation for companies and clients. So when our firm requires some advanced work, I do consult with Mr. Coons for his assistance.
And how would you assess, Mr. Tomasino, Mr. Coons' fitness? How good is he or not good is he at providing those services to you and your practice?
His overall, he's very good at what he does. He has matured over the years where I believe he provides me honest opinions about limitations that he may have, or if he's being affected by his disability, and we discuss that openly. I believe in the past, especially during this PCAOB situation, I wish he had consulted with me, because I would have advised him to get an attorney. And sometimes I think he was trying to try to take care of things too much, or was too proud to ask for assistance. But I think that this PCAOB matter, based on my professional opinion, could have been mitigated with an attorney and proper representation. I think the board understands that the peer review requirement in I believe it started in 2010, 2011 for small practitioners was a burden that for some practitioners was too much of a burden. I think he overestimated the requirements, but I've been part of the peer review since 1998, so I always knew what the process was about. And I can attest to this, that any engagement that he assisted with our firm, and then subsequently, if that engagement was selected by peer review, has always been a pass. We have not had any deficiencies on any of the work that he assisted on with me on any peer review review of either a compilation or a review engagement.
And Mr. Tomasino, you're aware of Mr. Coons's stipulated decision and the restrictions on his ability to practice beginning in 2016, correct?
Yes, I was aware of that.
And since that time, Mr. Tomasino, have you seen any improvements in Mr. Coons's professional practice? And if so, could you maybe describe them?
The first thing that comes to mind about Mr. Coons about this situation was instead of going, becoming depressed about it and maybe sticking his head in the sand, he took it as a challenge that I'm going to be a better CPA and at some point get to this point of having a hearing where he could demonstrate to the board members that he has rehabilitated, he has taken continuing education. I've seen Mr. Coons become much more resilient as far as his disability in the last few years, and the handling of this situation. I applaud him because, as what has been stated in this case, he did not damage any investor or any client. He basically did not follow administrative protocol in regards to what was required with the Pcaob. I see that Mr. Coons has become a stronger person. And in one way, this experience, his insight on peer reviews, and we did have a system peer review 3 years ago that he assisted me on. And that was the year I decided not to do audits anymore because the requirements are so stringent. You need to, you have to have a firm that specializes in audits almost to do. He actually helped us through that system review, and I applaud him for helping us with that. So that's my assessment of how Tim has handled the situation from 2016 to now.
Thank you, Mr. Tomasino. I have nothing further, Your Honor.
Okay.
Cross-examination, Mr. Descartes.
I don't have any questions, but I thank Mr. Tomasino for taking the time to participate and testify today.
Absolutely. I think Mr. Coons is an asset to his clients and to the profession, and that's why I'm here today.
All right. So, Ms. Reed, if you would like to poll the board, see if there's any questions for Mr. Tomasino, please.
Thank you. No questions.
Carrie Ann Farrell Hines.
Thank you.
Dan Jacobson. Katrina Salazar. D.D. Owens.
No questions.
Michael Savoy.
Thank you for being here, sir. While working with you, under you for the past few years while having a license restricted, did he perform any attest services under your control and supervision?
Yes, he did.
And I imagine they were exemplary?
They were exemplary. A couple of those engagements were pulled for peer review, and he assisted me, and we actually had a very good pass on both those engagements. One was a compilation with full disclosure, and one was a review.
Thank you, sir. No more questions.
No questions.
Yen 2? Okay, Your Honor, all the members hold.
All right, Mr. Tomasino, thank you very much for your testimony. You're excused as a witness.
Okay, thank you. Have a good day.
You too. And Mr. McLaughlin, any further evidence? Thank you very much. We'll next go to closing arguments. Mr. Descartes.
Thank you, Your Honor. I would make a suggestion in the interest of public protection. If the board's inclined to provide relief from the current attest restriction, that it only be to allow Mr. Coons to perform compilations and reviews. And that would be well tailored to his statement that that is why he's petitioning. He wants to do just those type of attest services. So I offer that up for your consideration. But I believe some showing has been made in terms of rehabilitation here. And I think all the facts are before you to determine if he's met his burden to warrant granting the petition. And that's it. Thank you.
Thank you. Mr. McLaughlin, your closing argument, please.
Very good, Your Honor. And thank you very much as well, ladies and gentlemen of the board. As you've seen, this evidence, we believe, supports a member who should be reinstated and have his practice privileges modified to allow at least the reviews and compilations. Mr. Coons has demonstrated not only, unlike your prior petitioner, full responsibility for his previous actions, and he has thus far behaved admirably after and during his period of probation. Some of the evidence you've heard today includes, for example, Mr. Coons meeting or exceeding his continued education requirements, paying his stipulated judgments or stipulated reimbursements, not only in full, but early. And additionally, there have been no other infractions or complaints against Mr. Coons. To the contrary, you've heard testimony here today, ladies and gentlemen, regarding Mr. Coons's what could be described as exemplary behavior thus far. We kindly and humbly put ourselves before you to reinstate his abilities to practice, and thank you for his time.
Thank you very much.
All right, thank you very much. So this concludes the hearing. The record's closed, the matter is submitted, and we are off the record. Madam Court Reporter, if I could get a page estimate, please. I'm sorry, did you say 50?
Yes, 50.
Very good. Thank you very much.
And I had an hit time of 3:15.
Mr. McLaughlin, as you probably heard me tell the prior petitioner, my office will forward you the court reporter billing sheet for this matter in case you or Mr. Coons decide to order a copy of a transcript at a later date. And then the board will adjourn to closed sessions shortly to discuss your matter and the first matter, but a decision won't be issued today, but rather will be issued later by mail. Okay?
Thank you, Your Honor.
All right. Thank you very much for both of your times. Take care. And Mr. President, I'll turn the matter back to you.
I believe we're going to be going into closed session now. So, Elizabeth, we have to make sure everybody's off before we enter.
Thank you, everyone. I'm going to log off.
Can we do a